August. I'll do it in August. Good luck. Well, what makes
Why are you sitting so far away? You're supposed to sit
that was
next to me.
that was the thing. Wasn't that right after one of our finals? That was
Everything will be very like. I mean, at least I didn't have to take days off. I mean, that's got
I did well. I did well.
We're just kind of yeah.
Welcome back. How was spring break? Was it a good spring break? Not long enough. Well, there's Easter break too, right? Yeah, I know this is what, the second Sunday of Lent, so Easter break's gotta be, what, about 2 weeks away? Am I doing the math right? Isn't it? I don't know. 3? 3 weeks,
I
okay.
hope I get a lot of jelly beans.
First, Easter break or spring break?
For both.
There's worse things to look like.
Yeah, you're so like a jelly bean.
Well, I hope it was a good spring break. Hope you found some time to relax. My daughter's birthday fell in there. My birthday fell in there.
Oh, when were they?
She's end of February. I was March 6th, which was Friday this year.
Nice.
Yes. Hey, thank you. Yeah, ripe old age of 49. So,
Who's 49?
me,
Are you really?
I am. So, now I got the gray hair and the glasses. Didn't always have those.
I can't tell.
You can't tell I have glasses.
I can tell you have glasses, but
Oh,
grace.
hey. I don't know. I kind of like the thought of gray hair. I always wanted gray hair. Believe it or not, I used to pray for gray hair. I started balding when I was, I don't know, 19, I'm gonna guess.
Oh.
I know in law school, I was practically as bald as I am now. So that was my specific prayer. I prayed that the hair would stay on my head long enough to turn gray. When I see the gray, I see a prayer answered, you know? So,
That's true.
and you know, I look good in the bald too, so maybe I should just pray for baldness. I don't know. But anyway, so we're back and I learned a new prayer. Not sure of its origin, but I heard the words and I thought, gosh, those are beautiful. So I'll throw that in today. And my prayer goes out to each and every one of you. I know there's a lot of worries out there about sickness. You know, I saw a Facebook post. I thought it was a funny joke. It was a woman saying to a man, honey, look, all my friends online that were constitutional scholars, now they're infectious disease scholars. And everyone seems to be an expert in everything, no matter what's in the news. So I am not an infectious disease scholar. I have no idea what the future holds for us there, but my prayers go out to each and every one of us for continued health and well-being. Hopefully we're all healthy. Hopefully everyone you know is healthy, and hopefully we got a strong and healthy world. Sound good? All right. In the name of the Father, and the Son, and the Holy Spirit, amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women. Blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, we fly into thee, O Virgin of Virgins, our Mother. To thee do we come, before thee we stand, sinful and sorrowful. O Mother of the Word incarnate, despise not our petitions, but in your mercy hear and answer us. And now that new prayer I learned, let's hope I don't screw it up. O Jesus, through the Immaculate Heart of Mary, we offer you our prayers, works, joys, hopes, and sufferings of this day, for all the intentions of your Sacred Heart, in union with the holy sacrifice of the Mass throughout the world, for the salvation of souls, the reparation for sins, the reunion of all Christians, and in particular, for the intentions of the Holy Father this month. Amen. In the name of the Father, Son, Holy Spirit. Amen. Would you like that? I thought the words were great. Anyway, welcome back. And today's topic is chapter 5. And chapter 5 talks about Article 4. How'd that happen? I don't know. But chapter 5 talks about Article 4 in Florida's Constitution, which is Florida's executive branch of government. Yes, surprise, surprise, as well as a legislative branch, which we covered last week. There's also an executive branch, which we'll cover this week. And there's a judicial branch, which we'll cover next week. Were you surprised that there were 3 branches? Probably not, but there they were. And here's the executive branch. So we cover that today. And we began this chapter like we began the last chapter and like we begin the next. We began it with an excerpt from this particular law review article that struck my fancy, despite it being kind of old now. It's from 1997. This one was called First Principles of Constitutional Revision. And here the authors talked about the executive branch. One thing they noted was that the executive branch is responsible for executing the laws that the legislative branch creates. And that goes back to Civics 101, does it not? No surprises there, I hope. And they noticed that while there is, as Locke suggested, an area of executive prerogative that arises from the legislature's inability to foresee all circumstances in which immediate action might be required, the executive risks being discredited whenever it acts without explicit legislative authorization, say the authors. They go on to opine. Consequently, it is constrained to act only in those ways unlikely to create public controversy. And I don't know if that's an opinion or wishful thinking, but certainly that was the opinion of the article written there. They did note, and we explore this later, just a few minutes later in the chapter, that Florida's Constitution has an elected cabinet. And from there, that brings us to a note and question to consider that I put in the book under this particular excerpt. Where is the line, under note 1, where is the line between executing the law and creating the law? And I thought that was an interesting note to note, because if you're not a constitutional scholar, if you're not even a lawyer, if you just happen to be an ordinary citizen who watches the news nowadays, it's not unusual to see that question arise. Am I right? Maybe we can think back a few years ago. Have we created a law, or have we just decided not to enforce the law on the federal level, for example? If we decide that we're going to put our lowest priority, indeed no priority, indeed no enforcement of immigration laws. If the federal executive declares that to be a policy, is that the faithful execution of the laws, or is that the making of the law? That's a question we have to ask ourselves. On the flip side, that's the question on the national level. What about the question on the sub-national level? What if an organized group, maybe it's a city, maybe it's a county or some other municipality, decides, we don't really like certain federal laws. We're a sanctuary from those laws. We don't like them. You don't have to like them either. Our law enforcement officers simply will ignore them, won't enforce them. Is that an example of the faithful execution of the laws by an executive? Or is that an example of lawmaking by an executive? So these questions arise. They arise on the national level, and they arise on the state level. Our emphasis in this chapter, of course, will be on the state level, but I just wanted to point out that although we may have a state level emphasis, certainly as your legal careers progress, you'll be encountering these particular issues not only on the state and local level, but on the federal level too, don't you think? These issues will come up. So I wanted to raise that up at one. So where is the line between executing the law and creating the law? What is the answer to that question? Well, if we were to answer it in the most simplest sense, it is the state legislature that passes statutes. Likewise, as we studied in an earlier chapter, it is municipalities that pass ordinances. This is the most basic answer. That is an example of lawmaking. But that's only a basic answer. What about the administrative code? We have a federal administrative code. Likewise, there's a Florida administrative code. To what extent are the rules and regulations in an administrative code a law? Well, from your client's perspective, does it really matter? If they can suffer a sanction, if they can suffer a financial penalty, if they can lose their freedom, if they can lose their fortune based on a violation of an administrative code in the same way that they can lose those things based on a violation of a statute or an ordinance, does it really matter to them that you call one a law and you might not call the other a law? If it's a compelled enforcement and an enforcement that has a meaningful penalty. From the layman's standpoint, from the non-lawyer standpoint, wouldn't that be called a law? So this question arises in its complexity when it comes to the administrative law. It arises in its complexity when it comes to the executive issuing executive orders. I tried to start last class with a joke. I mislabeled deliberately the three branches of the federal government. I called the executive the lawmaking branch jokingly, after I called the legislative the investigatory branch jokingly, and I commented jokingly that the executive branch had no choice but to make laws because the legislative branch at the federal level was too busy investigating things. Now, maybe I offended your politics, I hope I didn't, but there's something to be said about executive orders, whether they come from the office of the state governor or if they come from the office of the United States president, and viewing those as law. If they affect rights, duties, and responsibilities, isn't the layman, the non-lawyer, correct in referring to them as the law? So the question there, where is the line between lawmaking and law enforcement? That's a fuzzy one, isn't it? That line sometimes is not a clear line. So that's why I included that note there. So our next section in the text takes a look at the elected cabinet. And as we saw in the prior section, that was one of the things the commentators pointed out, that the cabinet is elected. Let's compare that truth here in Florida to our federal system. Where do federal cabinet members come from? Of course, when I say federal cabinet members, I'm talking about the President of the United States, right? And the federal executive cabinet. How did those individuals get their jobs? Well, they were nominated by the president, right? With the advice and consent of the Senate, right? So these are individuals the president picked. Afterward, the president maybe might not think the president made a good pick, who knows? Maybe a given president might send out a given tweet about a given cabinet member who's, no longer in the cabinet. Certainly, a federal president, the president of the United States, could make a bad choice. But my point is this, on the federal level, it is a choice. The choice comes from the president. Is that necessarily true on the state level? If the federal constitution requires the federal president's cabinet to operate in one way, does that implicitly require all state governments and the state executives, such as the governor, to operate in the same way? No. The state constitution can set up a different system. Indeed, here in Florida, under Florida's constitution, it is a different system. The Florida cabinet, the governor's cabinet, is not the choice of the governor. It is the people of the state of Florida who directly vote on candidates for cabinet positions. The reason individuals are in the governor's cabinet in the state of Florida is because the people of the state of Florida elected those specific individuals to the job. So in Florida, it's not a matter of the governor appointing someone with the advice and consent of the Florida Senate. That is not how it works in Florida. Instead, the cabinet members stand for election, and it's a partisan election. What about this? What if Florida's governor happens to be, pick a party, Republican? Does that mean that the people of the state of Florida must vote for the Republican choice when it comes to the cabinet members? No. The people of the state of Florida are free to vote for a cabinet member that happens to be whatever party the people of the state of Florida choose through their vote. The end result can be, and often is, in the state of Florida, the governor and one or more cabinet members might be different political parties. And since there are different political parties, they may have different points of view. Sometimes, when you put a Republican and a Democrat in the same room, they can find something they do not agree upon. True, right? Likewise, if you put a Republican and Democrat together on the same cabinet, they might find things they do not agree upon. So what we have here is an interesting application of that doctrine of subsidiarity that we talked about in the first chapter of our text. Here we certainly have a division of powers within the state cabinet. Indeed, you might have diametrically opposed political opponents serving in the same cabinet, if that's the result of the election. And that's how Florida is set up. So who do we have in the cabinet in Florida? Well, we look at Article 4. It tells us who is in the cabinet. We've got under Article 4, Section 4, subsection B, an Attorney General. Right now, Ashley Moody is our Attorney General. We have another cabinet member under subsection C that's called our Chief Financial Officer. Right now, Judy Petronas is our Chief Financial Officer. And we have yet another cabinet member under Article D, that's our Commissioner of Agriculture. Jeanette Nunez is our current Commissioner of Agriculture. These individuals were elected directly by the people, and they constitute the governor's cabinet, whether the governor likes them or not, under Florida's Constitution. So a very different system than you see under our federal Constitution. You notice in Article 4, subsection 4, in paragraph E, these individuals come together and serve various purposes, as well as occupying the office to which they were elected. For example, the governor, the Attorney General, the Chief Financial Officer, and the Commissioner of Agriculture come together and serve as the State Board of Administration under Article 4, Section 4, subsection E. What's that? What's a State Board of Administration? This is like an investment arm of the state of Florida. The state of Florida has financial investments? Yes, it does. What is among the largest financial investments that the state of Florida makes? The state pension fund. If you've ever been a state employee, you may have been eligible for a state pension. If you're a private sector employee, you may be scratching your head and saying, pension, what is this strange item of which you speak? Indeed, in the private sector, pensions are, in many industries, a thing of the past. They're simply not available. But for public employment, pensions remain widely available. They certainly are available here in the state of Florida for Florida state employees. Who's going to direct that pension fund? That's the State Board of Administration. And that's not the only financial job that they perform. They perform other investment roles also, but the bulk of their holdings are certainly held within the pension fund. Under subsection F of Section 4 of Article 4, the cabinet comes together and serves two other purposes. That's not a typo. I have two Fs because it's both in subsection F. So under subsection F, you see the Internal Improvement Trust Fund, and also in subsection F, you see the Land Acquisition Trust Fund. What are these two things? What are they doing? Well, when it comes to the Internal Improvement Trust Fund, this was set up for the purpose when our state entered the Union. The Congress deeded land to the state of Florida. It was the original holder of that land, and it remains the beneficial owner of that land for the benefit of you, I, and all our fellow Floridians. So the Internal Improvement Trust Fund took title to that land. That land can be bought and sold. If it turns into cash, now they're the beneficial holder of the cash. If that cash is used to buy other land, now it's the beneficial holder of that land. And this entity took on a life of its own and continues to this day. It's not all that different, but is different than the Land Acquisition Trust Fund. There, the state of Florida, through the legislature, which delegates it funds from time to time, and through its own fundraising activities, can buy land and own it as part of the state of Florida. Perhaps the state wants a state park. Perhaps it wants to preserve land. Perhaps it's acting in the interest of the environment. Or perhaps it's acting in the benefit of infrastructure. Need a railroad? Want some light rail? My wife drives to work, or I should say rides to work every morning on the light rail. Where to get the land to put the tracks, to run the train? This is the group that does it. Much infrastructure requires some land, and this is the group that acquires that land. Yes?
For these different funds, I'm just a little confused by this. Is it the Attorney General, Chief Financial Officer, and Governor that create the trustees, or do they appoint the trustees?
It exists and they become that group.
They are that.
So
group.
there are employees who work there and continue to work there as administrations come and go. So there are employees for these groups, but these 4 individuals consist of that group. These employees work for those 4 individuals as they come and go.
Okay, thank you.
So, and of course, elections change the cabinet members from time to time, but the entities themselves live on. And those whose W-2 or job it is to work for those entities, they don't come and go based on elections. So that's how that works.
Thank you.
And under Part G is the Department of Law Enforcement. Again, the cabinet comes together and serves as the head of the Department of Law Enforcement. But there's a great example. If you happen to be a law enforcement officer, you know that your job doesn't come and go based on who gets elected governor, right? So, but who's in charge of the agency certainly will change. So that's what we talk about there. We'll also talk about a heading called Enumerated Powers of the Governor, what it is that our governor of our state of Florida can do. What are the powers enumerated to the governor's office under Article 4 of Florida's Constitution? And the first thing we see the governor referred to, and I'll use the pronoun he because at the particular moment, Ron DeSantis is our governor. So we happen to have a male governor at the moment. But what we see there is that he is the supreme executive power shall be invested in the governor, and he is the commander-in-chief. And is that disingenuous? Does Florida have an army? And yes, Florida has an Army National Guard. And as you'll see in a moment, Florida has the right to call up a militia. So it's not disingenuous to refer to Florida's governor as a commander-in-chief. Under subsection B of Section 1 of Article 4, you see that the governor has the right to initiate certain legal proceedings. Subsection D spells out further that the governor has standing under Florida's Constitution to seek advisory opinions from the Supreme Court of Florida, and therefore the Supreme Court of Florida has jurisdiction to hear and answer those advisory opinions when that advisory opinion has to do with the duties of the executive branch. So the case and controversy requirement of standing is not necessary to be fulfilled when the governor brings such a case. Why is that? That's because of our canons of construction of Florida's Constitution. Our canons or rules of construction of Florida's Constitution say that when the Constitution explicitly spells out a way to do a thing, that doing that thing in a different way is unconstitutional. When Florida's Constitution spells out a way to do a thing, then doing that thing in a different way is unconstitutional. So what we see here in Article 4, Section 1, subsection C, is that the governor can seek an advisory opinion from the Florida Supreme Court, who then can issue that advisory opinion. We don't then say, oh, we're gonna add a case of controversy requirement on top of that, or that, oh, we have to make sure there's standing before we answer that, because the Constitution explicitly said how this thing is done. It does limit it when it comes to the governor to questions about the executive branch, but so long as that is the advisory opinion question that the governor seeks, the governor need not prove he has standing before he can file and get such an advisory opinion. So that's his power under subsection C specifically and subsection B also. Subsection D, as I alluded to a minute ago, gives the governor the power to call out the militia. Anyone familiar with the term? What does militia mean? Okay. Then perhaps I'm stumbling again into the potential of offending someone's politics, which I hope I don't do. But the definition of militia is not those who are already enlisted in and serving in the armed forces. The definition of militia are citizens who can be called up to supplement those who are currently serving in and enlisted in the armed forces. So that would be you and me. We could be the militia that could be called up by our governor under Article 4, Section 1, subsection D. And I already have offended some folks, so I'll move on from there. Article 1, subsection E says that the governor has the power to issue the State of the State address. Now, I'm sure you've had your programming that you're trying to watch on television interrupted by the President of the United States State of the Union address on more than one occasion. Have you ever had your programming on TV interrupted by the governor's State of the State address? Probably not, but it does exist, it does happen, and it is the governor's constitutional right and duty to issue the State of the State address. Also, under Article 4, Section 1, subsection F, the governor has the duty to fill by appointment those who have retired or passed away or been removed from office. Whenever there is a vacancy in an elected position, the governor has the power to fill by appointment that vacancy, and then she or he that is appointed to fill the vacancy holds that office, although not elected to it, until the expiration of the term of the original office holder. So, for example, the elected official had a 4-year term and died on year 2. The governor can fill by appointment that position. The appointee doesn't serve 4 years. The appointee serves 2 years under my hypothetical, because the original term was a 4-year term, but 2 were already filled, so therefore only 2 years remain vacant, and the appointee serves 2 years. See how that works? So we don't restart the 4-year clock, in other words. And that's the governor's power under Article 4, Section 1, subsection F. For those of you who are still awake, oh, there's a question. So you were awake, sir. That's awesome. Yes.
Does the governor have any removal power?
Yeah, the governor does have removal power. Absolutely. In Alea versus Scott, which we'll look at in a minute, we'll see a form of that removal power. That was more of a statutory. Yeah, am I stretching it, calling that a removal power? Yeah, there are statutes that can and have been argued to give the governor removal power. I'm trying to remember, because I don't remember reading the case law. I only remember watching the news articles, maybe even reading a news article. But there was, unfortunately, a shooting. There was a sheriff who the governor disagreed with the handling of it and wanted to remove the governor wanted to remove the sheriff. So I remember that being in the news in recent history. So that would be one example of at least an attempted power of removal. But it is statutory for the most part. As I'm sure you saw as we read through, God bless you, as we read through Florida's Constitution, there wasn't a great deal of removal power there when it came to the governor. And in doing that, I go back to something I raised in the last class. Some of you are happy I raised it, some of you were less happy. That we were all indoctrinated in our youth to see the 3 separate branches of government as separate but equal. And I asked you to question whether or not they were really equal. when it comes to the executive branch, the governor can be removed by the legislative branch, just like under the federal constitution, the president can be removed by the legislative branch. But can the president remove the legislature? No. Can Florida's governor remove Florida's legislature? No. So if the two of you are two of us, you and I, let's make an analogy. If you and I are allegedly separate but equal, but you could fire me at any moment, but I can't fire you, are we truly equal in power? You know, that's the kind of question I like to ask. I'm sorry to buck the trend when it comes to our civics education. We're all taught in elementary school, regurgitate the following on exam day, the 3 co-equal branches. You know, and if you don't regurgitate that on elementary school exam day, you don't get the A. I understand that. I'm not out to change the world, but I am asking you to take a look and ask yourself, now that you're not in elementary school, is that true? So when you talk about the removal powers of the governor, that reminds me of that issue. And certainly we have removal powers for the legislature to remove the governor, to remove others, to remove judges. Indirectly, we have removal powers of the judiciary, who can grant something like a writ of quo warranto or other extraordinary writ that might question a person's right and ability to continue to hold office. But we don't have exactly the same power for the executive branch. So let's not fall into that trap of thinking, okay, I identified a power of one branch, therefore that power also exists in the other 2 branches. That would not be a good argument to make in a court of law, because it's not going to carry the day. Oh, another question, yes.
No, just a comment. The governor didn't factor with
Is that how that story ended? So that sheriff,
Railroad County sheriff.
and that sheriff was out, and I'm sure the sheriff challenged that in court. How did it turn out?
Not followed, but I know there's a new sheriff, so that's probably gonna take some time. before that-
Yeah, to sort that out. Yeah. So maybe those court proceedings are still going. Yeah, thank you for that update. Yeah, so who knows, maybe by the end of the semester we'll see an outcome there. Oh, I'll have an excuse to amend the book. Yeah, but thank you for the update, I appreciate that. So I hope that addresses the question. But now I want to turn to the powers of the lieutenant governor. Who can tell us the name of the current lieutenant governor? Wow, this should be like Final Jeopardy, right? Okay, come on, who's got Google? Someone has Google? Google knows all, doesn't Google? I think so, I Googled Google. Google told me that Google knows all. So it must be in there. Yeah, who's gonna give us the lieutenant governor?
He's Cuban, I believe.
Jeanette Nunez?
Oh, no, didn't I call her something else earlier in the session? I think I called her the Commissioner of Agriculture. Okay, Commissioner of Agriculture, Nikki Fried. Lieutenant Governor, Jeanette Nunez. Thank you. All right. Yeah. So there we are. I think I've proven the importance on a day-to-day basis of our Lieutenant Governor, have I not? No, the Lieutenant Governor does serve an important task under Florida's Constitution. Let's talk about that. First of all, the Lieutenant Governor has duties as assigned. So as the governor assigns duties to that position, those become duties of the Lieutenant Governor. Likewise, Florida's legislature can assign duties to the Lieutenant Governor. So as statutes assign duties to that position, then those become part of the duties. So there you go. Also, just as the vice president under our federal constitution is called a heartbeat from the presidency, right? Because if the president's heart stops beating, then the vice president becomes the president, right? Likewise, the lieutenant governor becomes governor if our current governor passes away. Same thing there. What about impeachment? Has a president of the United States ever been impeached?
Yep.
Oh, yes, that has happened. Yeah, that has happened. Now, what happens, do you remember under the federal constitution? First, there's the impeachment under the federal constitution. Who does that? Yeah, the Federal House of Representatives. And after the Federal House of Representatives votes affirmatively and the president is impeached, then the president just goes home and takes a vacation? Is that what happens?
Nope, that was wishful thinking.
No, that's not what happens. The president remains the president despite the House of Representatives having affirmatively voted to impeach the president. And then a trial happens in the Senate, and that happens immediately, right? Because the House of Representatives runs over as fast as they can with those impeachment articles to the Senate. Is that what happens? On at least one occasion, they kind of drag their feet, right? Right, and then the Senate holds a trial to decide whether the President of the United States is removed. And while that trial is proceeding, is the President still president? Yes, the President remains president. And then if the Senate votes to acquit or just fails to vote to remove, then of course the President remains president. Only if the Senate votes to remove. At that point, then, the president is no longer president. So that summarizes impeachment on the federal level under the federal Constitution. Is that the required procedure for each of the 50 states? Does the federal Constitution require the same procedure for state governments? No. Each state constitution has the power to spell out its own impeachment procedures and removal procedures for the highest ranking executive officer of the state executive branch, for the governor. How is Florida's governor's impeachment and removal process different than the federal? Well, you'll notice that the lieutenant governor becomes the acting governor upon the impeachment of Florida's governor. So, unlike the federal president, who once impeached, remains in power unless and until removed by the Senate, unlike that, Florida's governor, once impeached, is no longer in power. And the lieutenant governor is the acting governor until the trial is over in the Florida Senate and until that trial results in either an acquittal or a failure to affirm the removal. So if you impeach Florida's governor, she or he doesn't remain governor while on trial. Is that good or bad? Guess it depends on which outcome you wanted of the impeachment, right? If you wanted conviction, then I guess it's good. If you wanted acquittal, then I guess that's bad. Or is it? What if you wanted acquittal, but the president, or I'm sorry, you wanted acquittal, but the governor is facing a time-consuming trial? Perhaps it's to the advantage of the governor that the governor can focus all of her or his efforts on the trial and need not be burdened with running the state of Florida while preparing for and then being on trial. I don't know. Maybe that was the logic. Constitution doesn't tell us the logic, but the Constitution of the state of Florida tells us the effect, tells us how it works. And that's how it works. What if you think your chief executive is just a Looney Tune and should be removed from power because of that? I don't know what's true, what's not true. These books come out on a federal level where some folks were alleging there was a plot afoot that our current president maybe could be removed based on an illness. Is that true? Is that not true? I guess only the alleged participants in that federal scheme could tell us for sure. But certainly under the federal Constitution, there's a method for accusing and then removing a president for being bonkers, for being Looney Tunes, for being mentally incapable to serve. Likewise, under Florida's Constitution, there is such a scheme, but it works differently. Here, there can be the docketing of a written suggestion. Let's take a look at the exact language in that. Upon impeachment of the governor and until completion of trial thereof, or during the governor's physical or mental incapacity, the lieutenant governor shall act as governor. Further succession as acting governor shall be prescribed by law. And I'm reading, of course, from Article 4, Section 3, subsection B. Incapacity to serve as governor may be determined by the Supreme Court upon due notice after docketing of a written suggestion thereof by 3 cabinet members. Okay. And in such case, restoration of capacity shall be similarly determined after docketing a written suggestion thereof by the governor, the legislature, or 3 cabinet members. Interesting. So in a way, it's kind of a war of papers, right? I guess if a fictitious Florida governor truly lost her or his mind to such an extent that they couldn't file a contrary suggestion, I guess that might be the end of it, huh? But we haven't had this play out in the state of Florida, so I don't have case law precedent to share with you. That would have been a cool case to include in this chapter, right? Wouldn't that have been a wicked cool chapter here? Crazy governor? Yeah, so. But the docketing of a written suggestion. Now, what if the governor herself or himself knows, I'm too ill to serve? That's provided for too. Read on, it says here. Incapacity to serve as governor may also be established by certificate filed with custodian of state records by the governor, declaring incapacity for physical reasons to serve as governor. And in such case, restoration of capacity shall be similarly established. So hey, say you've got the governor with a temporary but severe illness. The governor could file 2 successive written suggestions, right? And in between those 2 filings, the lieutenant governor would have the powers of the governor. So that's pretty cool, right? So that happens to us sometimes. And anyone ever been sick for a little while, they needed some time off of work? No, I have. Not lately, thank God. But it can happen. So if it does, it's nice to have a time off procedure in place, and that's what we've got here under Florida's Constitution. So some notes and questions to consider under enumerated powers of governor. Let's see what we've got there. Note 1, note that as an exception to the case and controversy requirements of Florida law, Florida's Constitution empowers the governor to seek an advisory opinion from Florida's Supreme Court as to the interpretation upon any question affecting the governor's executive powers and duties. And I mentioned that one already. I'll throw in another one that's also in Florida's Constitution. I mentioned here in Note 1. The same exception is extended to Florida's Attorney General. Remember that cabinet member? For the purpose of requesting a ruling from Florida Supreme Court as to the validity of any initiative petition seeking to amend Florida's Constitution. So with those 2 case and controversy waivers, if you will, found in Florida's Constitution, I pose this question: was it wise to accept these officers from the case and controversy requirement for these purposes? And who would voice an opinion on that? It's an opinion. It can't be right, it can't be wrong. Opinions are like noses, everybody has one. Yes?
I think it's right because it expedites the kind of process that they may be having in order to further any kind of legislation.
I like that point. And expediting that process has a valuable purpose when it comes to the ongoing function of government. We're talking about an executive branch that for some reason doesn't know what its powers or responsibilities are under the Constitution. That sounds like something we ought to clear up pretty quick. Likewise, we've got here a concern by the Attorney General that a proposed amendment to the Constitution itself might be unconstitutional. I don't know about you, but those parts of Florida's Constitution that are unconstitutional, those parts don't make me proud. Anybody look at those parts and say, yeah, that's great? Probably not, right? So it'd be nice if we could head those off at the pass and make sure they're not in there to begin with. So yeah, it does expedite things, it certainly does. But what's the bad side? If everyone else in the world has to meet a case and controversy requirement, why are these 2 above the law? Might be your argument. If I were to make that argument, I'd say the laws should apply equally, not only to those who lack power, but those who happen to be in power. If we, little folk, have to prove we have standing, we have to prove a case and controversy, then why shouldn't powerful government officials have to do the same. That could be an argument. On the flip side, turn then to note 2. Note 2 says, note that the governor shall fill by appointment any vacancy in state or county office for the remainder of the term of the office. For this reason, when a Florida court judge dies, resigns, or otherwise leaves before finishing enough of the term of office, the governor appoints a replacement to finish the term. And there I talk about that the governor can't just appoint her or his buddy. Doesn't work that way. We have some protection from such favoritism or nepotism. What we have is a judicial nominating commission, and I spell out how the JNC works in the body of that note. All the details are there. To summarize it briefly, we have individuals who are volunteers and are serving as this judicial nomination commission, who are reading and receiving the applications that arrived on time, vetting the candidates, choosing which ones to interview, and after the interview, providing the governor with a short list, at least 3, perhaps as many as 6 names. And the governor then, she or he must pick someone whose name is on the list to fill that vacancy. So you may be the governor's best friend, you may be the governor's lover or spouse or child, you may be the governor's biggest financial donor, but none of those things are going to get you appointed to fill a judicial vacancy. Unless, of course, you're one of those things and you're on the list from the JNC. So that's the point I raised there with point 2. Any questions about the powers of the governor or the lieutenant governor under Florida's Constitution? Hey, some of these parts are more exciting than others. This part's exciting. Faithful execution of the laws. And the case I raised for you here was Alaya, I hope I don't mispronounce her last name, Ayala. So that's anyone know her and know how to pronounce her name? I'm sorry? Ayala. Thank you. Yeah, and I'm standing in her former jurisdiction. So some of you may have voted for her, right? Some of you may have worked for her. Anyone here worked for her? No, okay. So Ayala, did I get it right? Versus Scott. What is this story about? Well, State Attorney Ayala for Florida's 9th Judicial Circuit made a decision, and after making that decision, held a press conference. What was that decision? Yes?
That she wouldn't pursue the death penalty?
Correct. That decision was that she and her office, so we're talking about all the prosecutors of Florida's 9th Judicial Circuit, a large and important circuit that's right here in Orlando, that's right here in Orange County. None of the crimes of Orange County would result in her or anyone else in her office pursuing the death penalty against the accused. And there were questions pro and con at that press conference, but it seems from the record that that press conference clarified one thing, that this was a blanket policy. This applied to anyone and everyone who might be prosecuted by her office, that this applied regardless of the particular facts of the case or the particular circumstances of the alleged criminal activity. Matter of fact, quoted from the record was, even where an individual case, quote, absolutely deserves the death penalty, end quote. That is what the opinion alleges that the record showed. So don't mistake this for an individual decision that an individual case would not result in a death penalty being brought against that individual. This was the state attorney deciding that there was no death penalty in her jurisdiction. How did then Florida Governor Rick Scott react? What was, yes?
Signed the executive order stating resign all those cases to
Correct. According to Governor Scott's executive order, all cases for which the death penalty was an eligible offense if the facts made it eligible for potentially asserting the death penalty, that case would be reassigned to the Fifth Judicial Circuit. Brad King happened to be the state attorney then. There was a filing in the record under oath from Brad King in his role as the state attorney, stating that the governor had not attempted to persuade him to exercise his authority to either pursue or not pursue the death penalty in any particular case. It was up to him whether to pursue it, but if it was death penalty eligible under this executive order, it automatically moved away from Ms. Alea's jurisdiction here in the Ninth Circuit and into Mr. King's jurisdiction in the Fifth Circuit. The difference being, if it stayed here in the Ninth, the state attorney was not going to consider it for the death penalty, even though it was death penalty eligible. Whereas under the executive order, once it was transferred, it would then be considered for the death penalty. The state attorney, considering it, might say, yes, let's go for the death penalty. The state attorney, considering it, might say, no, let's not go for the death penalty. But he would do so on a case-by-case basis. He didn't have a blanket policy like Ms. Alea did. So, yes.
So would she have just been fine if she did not just do this press release and then she just kept her mouth shut and just didn't pursue the death penalty?
Hey, great question. Love that question. I'm going to answer that question as we get to the end of this case. But just to make sure everybody heard it, the question was, would she have succeeded? Would she have been okay if she had just skipped the press conference and this had just been an internal policy of hers, just not made public? Great question. I won't fail to answer it, but let me finish the case first and then we'll explore that question because I love that question. So what happens here is that this comes before the Supreme Court of the state of Florida on a petition for writ of quo warranto filed by Ms. Alea. She doesn't like this. She doesn't like this erosion of her power. And under that doctrine of subsidiarity, we're supposed to respect the authority of lower sovereigns. Here we have an elected official, our state attorney. Here we have another elected official, our governor, maybe higher in the pecking order because governor outranks state attorney. But here we have an instance of the governor intervening, or you might say in the negative, interfering with the decision of another elected official. So think about that from terms of subsidiarity for a moment, but also think about that in terms of the litigation. Where did the litigation go? Well, Florida Supreme Court took jurisdiction. They have such jurisdiction of a writ of quo warranto, and in applying that jurisdiction, they looked for an answer within the rule of law. They turned to Florida statutes. Indeed, Florida statute 27.14 is quoted at length in the opinion because it gives the governor of the state of Florida authority to reassign cases from one state attorney to another. Turning to that rule of law, Florida Supreme Court found a legal standard upon which to review the decision of the governor. In applying that legal standard, one of the things they pointed out was that the governor has broad authority to assign state attorneys to other circuits pursuant to Florida statute section 27.14. They also pointed out that they were reviewing this for an abuse of that discretion. So, Florida Supreme Court was not picking a policy it liked best and applying that policy here. Instead, you might argue that Florida Supreme Court turned to the Florida legislature to determine the policy of the state of Florida. So we've got three potential sources for a death penalty policy, or more specifically in this case, for determining whether the existing death penalty policy would essentially be nullified in a particular jurisdiction, in a particular state circuit. We could turn to the executive branch. The governor clearly wants all death penalty eligible cases to be reviewed by someone who's willing to impose the death penalty under the facts of this case. We could turn to the Supreme Court of Florida. They could adopt a policy, or we could turn to Florida's legislature. And what the Supreme Court said in Alea versus Scott was that we're going to turn to the Florida legislature. When it comes to public policy, that's the proper source, says the Florida Supreme Court, under the implicit holding of this case. The statute requires that the governor have, quote, good and sufficient reason, quote. This was the legal standard that Florida Supreme Court found in the Florida statutes 27.14. So that's how we're going to review the case, says Florida Supreme Court. We're going to show deference to the governor in the form of looking for an abuse of discretion. We're going to ask whether the governor abused his discretion in saying that these facts constitute good and sufficient reason. And Florida Supreme Court held that under that standard, yes, there is good and sufficient reason for the executive order transferring any and every current and future death penalty eligible case from this particular circuit to the Fifth Circuit. So that's the holding of this case, but it brings us back to the question that you asked, sir, and thank you for allowing me to delay the answer. To rephrase your question, you asked, would this have worked? Would the Ninth Circuit State Attorney, Ms. Alea, have been successful if she simply implemented the policy and hadn't made it public? If she had just been quiet about it? And I believe the correct answer would be no. And here's why I think the correct answer would be no. Based on the holding of this case, the governor had the ability to transfer based on that policy decision. There would have been an evidentiary burden that didn't exist under these facts if the Ninth Circuit State Attorney, Ms. Alea, had done what you're suggesting. Just implement the policy, but don't go public about it. But in order to implement the policy, she'd have to feel that way and do that way herself. And she'd have to express to those prosecutors that she's supervising in her office that they have to do the same. So she'd have to promulgate the policy. She wouldn't have done it as publicly. And then someone would have had to make that policy public. One of the chapters we studied before this one was Florida's sunshine laws. It's awfully hard to keep a secret in Florida, thanks to Florida's sunshine laws. So perhaps these facts that you spell out in your hypothetical didn't happen. But if they did, perhaps the media would notice, why aren't there any death penalty cases anymore in Orlando, Orange County? Perhaps there could have been a very noteworthy case where everyone expected the death penalty. And indeed, if we remember 2017, some of us were Floridians then, some of us weren't, because I know we all come from all over the country. This particular case law precedent that we're studying comes from a very notorious case where a gunman killed 2 police officers while on the run from being apprehended. And in this particular case, everyone fully expected that the prosecutor would consider the death penalty under those facts. I was quite surprised when this case didn't result in a death penalty being sought by the prosecution.
He killed the girlfriend, she was pregnant. She was pregnant.
Yeah.
The first one was the girlfriend was pregnant.
Oh, no, I forgot about
The
that.
first girlfriend, then the second cop he killed, the other cop got into an accident going to the scene.
Okay,
That's
so,
what, but he still got,
so 2 police officers and a non-law enforcement
right, the girlfriend.
civilian woman who was pregnant.
was pregnant.
So we got 4 killed by this
Correct.
person. Yeah.
Oh, pay attention.
Yeah, someone should take attendance. That's a great idea. Thank you. I'm going to do that. Attendance sheets in the bag. And we got a whole conversation going, but I won't forget. I already forgot, but now that you reminded me, I won't forget. Thank you. All right. Yes, another question.
That was the only case out of the full 30 that went over to Brad King that actually got the death penalty.
Is that right? Wow, okay.
And then before that, Orange County wasn't really seeking death penalty for like a decade before that anyway.
Is that true too?
So it's kind of like our.
It's not?
Like that's why like
It
my
is?
problem with this case.
Some people say it's not, some people saying it is.
Like my problem with this case is that it's basically just Governor Scott saying, hey, you're not on my message, so I'm gonna point somebody to the position that is on the message.
So you see some political motivation there.
I see House of Cards going on.
Whoa, you mean the TV show House of Cards?
Oh, that's it.
Wow. Yes,
But isn't the state attorney basically an agent of the executive branch?
hey, great question, and you know that there's a part of this chapter that talks about how the state attorney is found under Article 5 of Florida's Constitution, which is the judicial branch, but yet it has functions in Article 4, which is the executive branch of Florida's Constitution. And the case law doesn't split hairs. They say that the state attorney is a creature of both, that they serve the judiciary but have powers under the executive. To be more specific, they say that the state attorney under Florida's Constitution has quasi-judicial and quasi-executive powers. So you raise a good question when it comes to these quasi-powers. You raise a good point.
And because of that, if, I guess, the governor let an agent of his office, I guess, branch, like, go rogue, wouldn't that create like a slippery slope to just create your own policies?
Yeah, and that slippery slope brings us back to one of the questions that opened this chapter. Where is the line between enforcing the law and making the law? When does the faithful execution of the law or failure thereof become an act of lawmaking instead of an executive act of implementation? Yeah, and then you see the line start to fuzz. That's a great point. It's a great point. That brings us to some notes and questions to consider. Note 1, under this case, did the court overlook the separation of powers issue? And I talk about how there was a footnote I omitted from the opinion where they answered that exact question. And it goes to the point that you raised just a moment ago. It talks about Folk versus State out of the 5th DCA, where the 5th District Court of Appeal holds that state attorneys, like all attorneys, are officers of the court. And although that's true, the execution of criminal statutes by enforcement, including prosecution, is an executive function of the government. The state attorney, when acting as a prosecuting officer under Article 5, which is the judicial article of Florida's Constitution, and under Chapter 27 of the Florida Statutes, is performing an executive function and not a judicial function. Therefore, according to this footnote, the holding of Folk versus State explains why this case doesn't raise an issue of separation of powers. Florida Supreme Court viewed the case as raising the issue of scope of Florida's executive power, not a separation of powers issue. A dissenting opinion, also omitted from the book, disagrees. So that was note 1, and that's what you raised in your question, and that was well raised. Note 2 talks about, in light of this opinion, what is a Florida elected official who holds the power of discretion as part of their elected powers supposed to do when faced with a law that the elected official finds morally repugnant? And let's break that question down. There are elected officials who hold the power of discretion, isn't that right? For example, if a prosecutor believes she or he can win the case, does that mean she or he must prosecute? No. Prosecutor has the power of discretion. Not unlike a law enforcement officer on the street. If a law enforcement officer on the street sees a misdemeanor, must the law enforcement officer make an arrest? No. Law enforcement has the power to make the arrest, but has the discretion. Likewise, the prosecutor, after the arrest, has the power to prosecute, but has the discretion. So now, what about an elected official? As part of their duties, powers, and responsibilities, there is discretion. What's that elected official supposed to do with the law that the elected official finds morally repugnant? And to make that question even harder to answer, I'll point out this requirement under Florida's Constitution. We talked about a cabinet member called called the Attorney General. The Attorney General has a duty, if the Attorney General intervenes in a lawsuit where the constitutionality of a statute or ordinance or a government action is at issue, the state attorney has the duty upon intervening to defend the government. So under Florida's Constitution, say you bring a lawsuit on behalf of your client, and your lawsuit says, pay no attention to whether my client violated that law is unconstitutional. I'm here to prove the law unconstitutional. Florida's Rules of Civil Procedure and the Florida statutes require you to provide written notice to Florida's Attorney General that you're challenging the constitutionality of that statute. Your suit can't go on until you can sign a pleading and file it in the court file stating that you've given that written notice. When Florida's Attorney General receives that written notice, Florida's Attorney General has discretion. They can either join your suit as a party, and they have the constitutional right to be seen and heard as a party, or in their discretion, they can not join. But if discretion is exercised by Florida's Attorney General to join your suit, the side the Attorney General is on is clear, is mandated, and is required. The side is in defense of that statute. So you'll never get the Attorney General to join the suit and join you in alleging that the Florida statute is unconstitutional. Under Florida's Constitution, if the Attorney General joins the suit, she must argue that the statute is constitutional. That's the only position she can take. Remember, she didn't have to join the suit. But if she joins the suit, that's which side she's on. So now with that additional knowledge, I ask you again the question that we see in note 2. What's an elected official with discretion supposed to do with a law that the elected official finds morally repugnant? What do you think?
They should keep their emotions out of it.
So your opinion is keep your emotions out of it,
Yes,
do your job.
that is my opinion.
Your opinion.
The death penalty is legal in Florida, so if you want to be a prosecutor, you have to sentence people to death. If you
Okay.
feel like you can't do that, then you can't do your job.
Okay, so in your opinion, if you feel you can't do it, that means you shouldn't have the job.
Right.
Okay? Yes?
That's tough.
Oh, it's tough, but is it incorrect? Now, of course, we're talking about opinions, so there's not a right or wrong here, but I can see the point.
I want people's feelings involved. I want this to be just like what they're doing. Like, if they think it's morally repugnant, if they're like, okay, all these street situations, there's possibly that kind of. I don't know, I'm a very much rules guy.
Okay.
I follow level structure.
Yeah.
So like, I can see some leeway, but definitely that blanket policy, I'm not pursue. I can see that.
Okay,
Force of that. I thought that was very persuasive.
yeah.
Yeah,
So you like the outcome?
sure.
Okay. Yes. What-
If she looked at it by a case-by-case basis, it
Uh-huh.
would be different, but just to say, I'm never gonna give anyone the death penalty ever, she's not fulfilling her duty as a prosecutor in the state of Florida.
Yes, she certainly, under these facts, under this case, she certainly had a blanket policy. No dispute there in the facts. So you're saying that having such a blanket policy, that disqualifies you from office. Is that your opinion?
Correct, because
Okay.
it's still law under the state of Florida.
Yeah.
I'm not saying I'm for the death penalty, I'm saying that that's a position that she works in, that she should follow the law.
Right. So if you take the job, do the job.
Right.
Okay? What's your opinion?
I think doing the job doesn't mean that you have to enforce the law that you find morally repugnant.
So you come to the opposite conclusion, but based on the same facts, you're saying part of the job is discretion.
It's-
Okay?
I completely agree. I just think that you have to look at it from a perspective.
Yeah.
Where exercise discretion where you think is needed. So I agree, but do not have a blanket policy because sometimes you take a job to make a difference.
Yeah.
Because there are situations where you need to exercise exercise discretion. And I just think, in a case where you find that this is, enforcing the law, it goes against everything you stand for, shut up and do it. I think that was done this time around. There would have been an issue if it's a long-term, broad statewide policy. But I mean, if I'm going to exercise discretion, in a case, I'm not just gonna go, in this particular case or two cases, I'm not just gonna go advertising.
So you don't like the advertising part. But let me pick up on, and I won't miss any of these questions. Let me pick up on one phrase that you used. You talked about take the job to make a difference. I think I paraphrased you well there. I hope I did. And isn't that true for so many public service, for so many elected officials, for so many public benefit jobs? You know, you take the job to make a difference. So if you take the job to make a difference and the job has discretion, you might exercise that discretion differently than another office holder might. Right? There were 3 other hands. Yes.
I'm gonna say, I think it's humans, we are always growing and learning more.
Yeah.
Who's to say-
At least I hope I am.
And who's to say she didn't realize that the death penalty does affect, a certain class of individuals disproportionately more than it affects others.
Yeah.
So who's to say that she didn't have that train of thought to say, you know what? Yeah, I may have, been elected or gotten this job based on one belief, but since I've been in office, I've noticed that, I'm really only affecting this class and this citizen. It's very hard to throw your emotions out of the window just because you simply, got a job and now you're starting to learn more about yourself and more about the job.
I'm hearing you raising 2 different and 2 good points. And the first point I'm hearing you raise is that perhaps at the time this particular prosecutor in the case took the job, maybe that wasn't her opinion, maybe that wasn't her goal, maybe she didn't take the job in order to make the blanket policy. So maybe at the time she got the job, even if, for those of you who feel it was disqualifying to have these feelings, maybe the time she got the job, she didn't have the feelings at that time. So maybe she wasn't, for those of you who feel it's a disqualifying feeling, maybe she wasn't disqualified at the time she took the job. And the second point I hear you making, and another good point, maybe once she had that different perspective, she had access to different data, she could see the cases in front of her, who they were affecting, maybe she saw a need for change. When we talk about the doctrine of subsidiarity, one of the proponents or reasons you might favor subsidiarity is that those who are closest to the problem might be best to measure the effects of the problem. Remember in our first lecture, I talked about something as mundane as a pothole, and I offered the preposterous solution. Maybe the entire United Nations should assemble to determine whether the particular pothole in your street should be filled. And of course, that's a ludicrous suggestion. They're so far removed from the problem of the pothole. But here we had someone with boots on the ground, someone with eyes on the particular files in that office, perhaps could see a problem that maybe someone in Tallahassee couldn't see. So I think you're raising 2 great points there. And they're points of opinion. You might agree, you might disagree, but there were 2 other hands, and I don't want to neglect them. I don't know who was first. You were, okay, you were first.
Yeah, I think the only real issue was that she didn't run on that platform. She didn't say it until after she got elected. There's a good chance she probably would have still got elected though,
Yeah.
but she didn't say before that she was never going to seek it. I don't think it disqualifies a prosecutor, but she's an elected official. That's what she wanted to do. She should have said that first.
I like it when you're talking about the electorate. You're talking about why the electorate voted for this particular candidate.
Yes,
Yeah, and you're talking about accountability, government accountability. You're talking about
but if she would have
doing the
said,
job you were elected to do based on what you promised to do at the time of the election.
right, if she would have said it before, I don't think it's nearly as much of an issue. That's what the people in Orange and Osceola
Yeah.
wanted.
And I think you raise a great point, especially when it comes to accountability. When it comes to some office holders who have discretion, they're directly accountable to you and I. I'm thinking, for example, a state senator, state House of Representatives member. That person starts voting in a way that their constituents don't like. What do their constituents do? Vote them out of office, right? But here we've got an example of a different office holder, maybe not as directly accountable. So if that office holder doesn't do what that office holder promised the electorate they would do, who can step in? Who has the power? By analogy, what about judicial restraint? What if I elect a judge who says, I call balls and strikes? Elect a judge who says, I call him as I see him. Elect the judge who says, my job isn't to invent the law, just to apply the law. Elect a judge who says, I'm simply going to determine what the facts are, and then justice is blind. I will apply the law, and the outcome will be what it should be based on those facts. What if such a judge then becomes an individual who says, I took this job for a reason. I have whatever it is. I have a political goal. I have whatever it is, a religious goal. I have whatever it is, a doctrinal goal. And instead adopts a policy of judicial activism. You know?
Do that all the time.
And we've seen it. We've seen accusations of it. Maybe we've seen the realities of it.
They do it so they get reelected. Do it all the time.
Yeah. And for some judicial positions, there is no election or no real election. In our next chapter, we'll look at Florida's Constitution, we look at appellate judges, and we look at their, every 6 years, we ask the electorate, yes or no, shall the judge remain the judge? There's no opposing candidate. It's just yes or no, would you like to keep this judge in office? In the entire history of our state of Florida, how many judges have lost their job based on such a ballot? I hear silence. That's the correct answer. The answer is 0. There's never been a judge who's ever lost their job based on the ballot that says, shall Judge so-and-so or Justice so-and-so remain in that position? So yeah, what about accountability? You raised issues of accountability. I think you raised great issues. Yes.
It seems like it's a lot about what, I guess, how discretion and
Yeah.
using discretionary opinions is defined, because a lot of people are going with morality and according to your morals, how would you use discretion? But I think there's another venue to use it when, how would you use discretion of a law, like how would you apply the law to these specific facts of a case? Because you can always argue the law can be applied one way or the other. And so I think discretion is more how would the law apply here as opposed to what do I feel personally is right or wrong.
Okay.
In terms of the death penalty here. So I think discretion can be defined 2 different ways. And
So
that's the issue.
you're seeing 2 different definitions for discretion.
Yeah,
And I see that point, and it's a good point. And I think it raises this issue. What are the boundaries of discretion? And I don't mean that only from a legal standpoint. Here, the boundaries were whether there was an abuse of discretion. That was the standard of review on appeal. But what about on a personal level? What if you are the office holder and among your powers is discretion? How do you put a boundary upon your discretion? In your own behavior, you put boundaries on it. Perhaps you call those boundaries your morality. As an office holder, are you going to turn off your morals? Are you going to abandon your morals? Are you not going to turn to your own morals when determining how you exercise your own discretion? So maybe that's the kind of issue you're raising there. But in raising all these points, I'm not trying to indoctrinate, I'm trying to educate. Perhaps you agree with the outcome of this case, perhaps you disagree with it. Perhaps you agree there should be discretion, perhaps you disagree with that. But the most important thing we can do here in law school is that critical thinking, and I've heard a lot of critical thinking right now, so I appreciate that, appreciate it very much. With that said, we're late for our break, so let's take a 10-minute break. That's gonna get us back here approximately 7:15, at least according to that clock on the back wall over there. And we'll certainly have plenty of time to wrap up this chapter, and I won't waste your time, since this chapter doesn't fill 2 hours. We'll begin to cover another chapter. So I'll see you in 10 minutes. Thanks for reminding me about the reminder.
I don't know a lot of those things.
No, I agree with that.
There can be, it's really hard to.
Which is why.
I think that makes it better. Like the less you're making people
Professor, did you say first freshman 6
the more you
finish
feel
up to
better.
5?
You know, that was the original plan, but then it really breaks that chapter into pieces where those pieces drop.
I feel like you should.
I think the better
emphasize
thing-
discretion
I'm-
and just go.
Well, I could do that, but instead I was gonna cover a part of separation of powers instead of legislative. So it's gonna leapfrog over legislative and onto separation of powers. That chapter can be broken into two without really messing anybody up. Whereas breaking the judicial chapter into two could really mess people up. So I had second thoughts about that. But I was right in saying this chapter doesn't cover 2 hours.
Yeah.
But I was wrong in saying we should cover the next chapter piece. And there'll be chapter after that that covers.
I can't remember.
Yeah.
She has to approve the list. No, I'm saying for you.
Oh, I don't.
Is that already come?
Oh, yeah, no, I don't.
Did you get the email about the transcript on it?
Yeah, how they sound, they look like not on track. Basically, it's the person I got. I feel like we got okay.
Well, I have my professionalism. I just need to submit it, but we don't have any experiential classes.
What are the